Joining me right now to help us understand this better is Mr. Prashant Bhushan, one of the lawyers for the main petitioner, which is ADR, or the Association for Democratic Reforms, and Mr. Sanjay Hegde, senior advocate with the Supreme Court. Gentlemen, good evening, and thank you for joining us. Mr. Bhushan, congratulations. This is a victory for the citizens of India for the right to information. But we had a lot of talk today, including from Mr. Rahul Gandhi, who's a former information officer, saying that it's very likely they will find ways never to make this information public. What's your response to that?
No, firstly, I want to say that it is a very important judgment which can have a significant impact on our electoral politics of this country, because the judgment also talks about the role played by money in elections and the need to curb it, and also mentions the dichotomy between a limit on spending by candidates versus no limit on spending by political parties. To put that in perspective, you see, the limit on candidates is about 75 lakhs for Lok Sabha elections, 75 to 90 lakhs for Lok Sabha elections, which means for putting up 500 candidates in a Lok Sabha election, the maximum expenditure of all the candidates of a political party would be less than 400 crores. As opposed to this, the BJP has collected 10,000 crores by way of electoral bonds alone in the last 5 years, and probably another 10,000-15,000 crores otherwise, apart from whatever they have received in cash, which is not even reported in their expenses. So therefore, that is some at least 20, 30, 40 times what their candidates can spend in one election. So therefore, this makes the fact that there is no limit on spending of political parties makes mincemeat of the limit on spending of individual candidates. Besides, you see, there are lots of candidates and even political parties who spend money in cash, which is not disclosed. That's why candidates are routinely spending 10 times, 20 times, 50 times the limit on expenditure, because they do not disclose what they are spending in cash. When this government brought this demonetization, one of the things claimed by them was that this was to limit the cash economy and make people become cashless by spending everything through banking transactions. Now, I can understand that you can't ask individuals to spend everything in cash, but you could have certainly asked political parties and candidates. Yes. This would, to some extent or significant extent, have minimized this abuse of this system of illicit funding of political parties and candidates, etc. So, while this judgment kind of does strike a blow and does talk about this bane of money in electoral politics and strikes a blow for our democracy to that extent, but this by itself is not going to curb this whole menace of illicit political funding or sort of non-level playing field between parties, ruling parties which have access to so much money, and opposition parties which have virtually no money. Yeah.
Well, I want to point out to our audience that both Mr. Hegde and Mr. Bhushan argued for the petitioners in this case. It's a victory for them both. Mr. Hegde, congratulations to you as well. Mr. Shailesh Gandhi again today was arguing that in this judgment, there is room for donors to come back and say, when I made the donation, my understanding was that it would be anonymous and it would not be made public. So now making it public would be a violation of my right. Do you see there's any room for that argument, Mr. Hegde?
Well, lawyers will make all arguments as long as they're paid for it in things other than electoral bonds, but I doubt that will be entertained.
Okay.
The point is that everybody already knew about this petition. This petition was filed and lying there in the Supreme Court for 5 years. I appeared for an intervener in this matter. They also had the option of intervening. And they chose to sit out. The question is not about the donors. The question is about the validity of the bonds themselves. It's like saying that if a court were to say that a building is illegal, you have to bring it down. Then it doesn't have to listen to each flat buyer saying that I put in my hard-earned money, etc., etc., etc. So there may be applications, but I doubt they will be entertained.
No, you see, in this, they had passed an interim order in 2019
Yes.
asking the state bank to disclose this information, or the political party to disclose this information to the election commission. So, and they have only asked for disclosure of all the information about electoral bonds after this interim order. So, effectively, the Supreme Court is saying that, look, everybody had been put on notice that this information may get disclosed when this petition is decided. And therefore, nobody can now claim that, look, when they gave this money, they were under the impression that this information would not be disclosed, etc. Quite apart from the fact that that's not a viable legal argument. But other than that, Supreme Court had put everybody on notice in 2019 that this information may get disclosed, and therefore they have ordered the disclosure. And to answer your first question, I feel that this government will be quite desperate about not getting this information revealed about who has donated to whom, because this will open a can of worms. Because mostly you will find that the donors are those corporations or connected with those corporations which had received contracts from or had got favorable policy changes from the government. Therefore, most of these donations would be found to be in the nature of bribes. And if that is the case, then those people can be prosecuted for bribery. For example, if a company had got a contract from the government, and if it had donated, say, 100 crores, if it had got 1,000 crore contract and it donated 100 crores by way of electoral bonds just before or after it got that contract, then certainly that would be a case for bribery.
This is really interesting, and this is my question to both of you. Are you saying that in the next 4 weeks, as citizens, as journalists, as lawyers, we will have access to information where we can trace every single donation that has come in over the last 5 years, and then be able to match it with tender awards that the government has given out? And are you also saying that we can actually draw a string between the two and say this was a quid pro quo? Because what is the window of that understanding? Is it a month? Is it 6 months? Is it a year, Mr. Hegde?
No, see, you will have data. The data which you get, which will basically be who bought bonds at what point of time, what was the company. Now, that data, when triangulated with other data like company returns, which are there on the registrar of companies, plus if that company has had any particular government dealing at that particular point of time or shortly thereafter. See, electoral bonds are often issued just before elections, and they are given to political parties around that time. So supposing a political party which was not in government comes into government and immediately passes an order favorable to a particular donor, then inferences can be drawn and maybe prosecutions can be launched. But the thing is, it's not as if you get ready-made data saying that X purchased these bonds on this date and it was donated to Y party. The donations themselves to the party could have gone through various formats. Somebody may have purchased the electoral bonds. Those electoral bonds are transferable. And ultimately, a third person or a fourth person may have gone and given it to the political party concerned, which finally encashes it.
Yeah, but still, you see, if you can trace the connection to a company which has received from benefit from the government or from the political party to whom the bonds were given as donations, then certainly it will open up questions of quid pro quo, etc. And that's what the Supreme Court has also discussed in this judgment, that it could well be that much of this donation is actually a quid pro quo by way of getting favorable contracts or getting favorable policy changes, etc. So, yeah.
There's also been a rumor, I must accept, on Twitter today or X today about the fact that SBI and the election commission might ask for more time, more than the 3 and the 4 weeks that have been given to them by the Supreme Court. Mr. Bhushan, do you think they require more time, given that the RBI has been very clear that KYC is top priority for the RBI and everything is, all data is carefully maintained?
No, there is no need. They can do it tomorrow. They would have all that information ready made. They know the number of the bond. They know who purchased that bond, because at that point of time, they took this information from the purchaser. They know which political party encashed that bond. All that information is there with the SBI in a digital format. They can disclose it today itself. There is no issue. There is no question of their seeking more time. But my fear is that this government will try to bring an ordinance to get around this judgment, as they have done in the selection of election commissioners case.
Yes. Mr. Hegde?
Well, I don't think an ordinance will be very easy. As far as the election commissioner's case is concerned, there was a window there where the Supreme Court said that because Parliament has not legislated, we have given guidelines. Long ago, in the Kaveri case, the Supreme Court itself said that you cannot directly overrule a judgment. It can't be that Parliament or the legislature is a super Supreme Court. So if something has been held to be unconstitutional, supposing it was for lack of legislative competence or something of that kind, then that would be a curable defect. You cure it. And
you are right, Sanjay. You are right that this amendment or ordinance would be invalid, because this judgment is premised on Article 19(1)(a) rights of the people. So
Yes.
that ordinance would be unconstitutional. But nothing prevents them from bringing an unconstitutional amendment, just as we have said that even that amendment which has been made for the selection of election commissioners is unconstitutional, because even that judgment is premised on the fact that if the government alone decides the selection of election commissioners, that poses a threat to free and fair elections and thereby to our electoral democracy. So, strictly speaking, even that amendment is unconstitutional. You see, initially in the first ADR case, the Supreme Court said that for the citizens' right to know, the candidates need to disclose their criminal antecedents, their assets and liabilities, etc. The then government brought a law to overturn that by saying, no such information need be given. That was challenged and that was struck down, but it took some time to strike it down. So I think what the government may try to do is still bring that ordinance in order to somehow buy time, that by the time the Supreme Court deals with that ordinance and strikes it down, it will at least take the matter beyond the election. Something like that they might try.
So basically what Prashant is saying is that they might try something of a temporary fix, a jugaad as it were.
Yes.
But that also has a political cost. And so close to the elections, I don't think jugaads will necessarily work. And there is the other thing, that there is normally a presumption of constitutionality as far as government legislation is concerned. Now, here, whether after it being struck down on constitutional grounds of being manifestly arbitrary, if it were to reincarnate through an ordinance, I doubt it would be received with the same tender care that other legislation is received.
Well, Mr. Hegde, I must ask you this. This was a 5-judge bench of the Supreme Court, cited by the Chief Justice of India, with two, next Chief Justices in line also on the bench. So, if any of the parties are looking to appeal, what are the odds of that going through or that being entertained?
There's no question of an appeal, but parties are free to file review petitions, and then the Supreme Court sometimes takes time, dealing with review petitions. Review petitions technically can be filed within 30 days of receiving the certified copy of the judgment. So we are on February 15th. If you file a review petition on the 15th of March, and then
but that will not lead to a stay of the judgment.
yes, there is no stay. But equally, if the government then does not, the government or the SBI does not take the necessary steps, they'll say there is a review petition pending. Often governments grant themselves stay, and it is quite an effort for the courts to then come in and say, okay, we are taking up this issue in contempt. So yes, there are several ways that a government can slow walk the process, but it comes both with a legal and political cost.
I do want to ask you this, though. The government has, through the Electoral Bonds scheme, changed the RBI Act, the Representation of Peoples Act, the Companies Act, the Income Tax Act. And we understand from RTI, the RBI raised some serious concerns back in 2017, saying that this will lead to money laundering, forgery, and cross-border counterfeiting, which the government just completely sort of skipped over, saying this just didn't come in time. The Election Commission raised concerns. What is now the locus standi, or basically the credibility of these agencies and the regulator if the finance ministry no longer takes anything seriously? I mean, if the RBI is not taken seriously in a matter like this, then where does that leave the RBI?
Faye, unfortunately, I have to go. My guests have come. So, thank you. Huh?
Thank you for joining us. Congratulations again for today. These victories don't come often. Mr. Hegde, question to you. The RBI and the Election Commission flagging problems on electoral bonds, but the government went ahead and did it anyway. Where does that leave these organizations, institutions?
No, it often happens that institutions say no, and yet the government of the day goes on right ahead. Later on, when the government lands with egg on the face, the institutions say, look, I told you so. But it is a rare institutional head who takes it as a personal affront if his advice is ignored. And then at best, the institutional head can say that, look, not in my name, I quit. That very rarely happens. Today, yes, in retrospect, a government may well say, oh, yes, we were warned by the RBI, we were warned by the Election Commission. And now that the Supreme Court has struck it down, we should not go down this adventurous path again. But this is a government which revels in its dominance. It does not like to be told that it is wrong. So and also there is always the theory among bureaucrats and lawyers that if you can kick a can sufficiently down the road, the problem will be that of the next government. If the next government is the same government which is re-elected, then the mandate sort of magically cures many things. If it is not re-elected, then whoever is the successor can handle it.
So, will all of the laws that were changed when introducing this scheme now revert back to their previous forms? So the RBI Act, the Representation of Peoples Act, all of those changes now, the Companies Act, those changes get removed?
Yes, those amendments get struck down. So once any legislation is struck down, it is as if it was never on the statute book. So those provisions will go back to their unamended stage.
Mr. Aida, I also want to ask you this. Now, the electoral bonds were introduced in 2017. The first sort of interim order that Mr. Bhushan was referring to was 2019, after which we've waited this long for this verdict. Justice delayed? Was it allowed to go on for too long, Mr. Aida?
Well, let's put it this way. When I first came into the profession in 1991, there was a matter relating to the privy purses, which the Supreme Court had struck down way back in the early 70s. Thereafter, the government brought in a constitutional amendment. The constitutional amendment, the final challenge, was only heard in the year 1992. So that made it 20 odd years. So given the fact that constituting a constitution bench of 5 judges, which disrupts the working of the court in other matters, ordinary criminal matters, or people who want their properties back. So I don't think it was all that long a delay. But of course, this is a Chief Justice who has been having constitution benches one after the other. And for a couple of years, there was also COVID, under which not too much work got done.
Yes.
So yes, there were reasons why this matter got delayed. But thankfully, it has been heard at last. And after the hearing, within a period of, while a lot of us expected that the verdict also would possibly come after the Lok Sabha elections, this verdict has not been delayed. It has come in time to have an impact on the finances of the next elections. So, I think here at least the Supreme Court deserves a little pat, a little acknowledgement.
Just a little pat. Will it make an impact before the upcoming elections, or have all the fund transfers already been done by this time?
Political parties need money by the ton during elections, and whatever they have is not sufficient.
Never enough.
Never enough. So the corporate donor who could anonymously carry a corporate bond in a little envelope and hand it over to the people concerned, that person doesn't exist. In fact, while I was arguing before the Supreme Court, I gave them an illustration. We all remember that during the Harshad Mehta scam, Ram Jethmalani held a press conference and demonstrated how 1 crore could be fitted into a suitcase, which he alleged had been left at the then Prime Minister's house. Now, if you have a anonymous corporate bond, electoral bond, you don't need a suitcase. A mere envelope will do. Now, that kind of envelope jugaad has now been taken off the table. Of course, physical transfers of cash come with their own problems. And the Election Commission used to catch a reasonable amount of cash from time to time.
So, Mr. Hegde, this idea that we can actually look through each donation and perhaps figure out whether this is a quid pro quo or not. We also have some members of our viewing team that's saying, what about the PM Cares Fund? Does it require a similar sort of judgment, a similar sort of look at?
Well, the PM Cares Fund is a different thing altogether. The PM Cares Fund is where the PM is trustee of the fund. There are donations made to the fund and payments which are being made out of it. And there it is audited like any other trust. So there are huge conceptual issues I have with it, because it almost sounds like the same kind of trusts which the late Mr. A.R. Antule launched in Maharashtra, where people made donations to the trust and allocations of cement bags were made.
Yes.
So here, this fund was launched at a time of crisis. Where how much has actually been paid, paid in, and how much has been paid out, and to whom? those the facts are not yet in the public domain. I'm not very sure where exactly the litigation is challenging the non-disclosure as such, but because it is a trustee fund like any other public trust, the returns will be given at the appropriate point of time to the commissioner of trusts or whoever is the authority. From there, if data can be elicited in a manner known to law and then worked on, maybe you will have a similar situation.
Will this set the cat among the pigeons for corporate India? Because we do know there's going to be a lot of people very nervous in boardrooms. Because now, if you're saying that the quid pro quo connections can be made, people perhaps be looking back at all donations. But if we compare it to maybe the listed companies and the announcements that they have to anyways make public, is there room here for the ED to be far more active than it has already been?
Do you expect that organization to be active? I don't think so. Not currently. Okay. Yeah, and I did point out to the Supreme Court how various listed companies then concealed it at different places in their balance sheet as miscellaneous expenses, where though they had made the donations, the reporting was in certain places where almost nobody could find it.
Yes.
So yes, there might be a certain nervousness, but till the data is out publicly and then it is triangulated and then a specific case is made out, I think the corporates will have their legal teams scaring them quite a bit, and it's good that they disgorge some money to their lawyers.
It's interesting. At the end of the day, there's always a lawyer, and there's always a team. Mr. Hegde, congratulations again on this win, and thank you so much for speaking with us. It's always a pleasure to have a conversation with you. This, like you said, is a judgment that gives us all hope, perhaps reinstills some vigor in democracy. That there are still checks and balances that work well. Hopefully, the other checks and balances, which is Parliament, the media, the opposition, our investigative agencies, will also do their bit in this case. Mr. Hegde, have a good evening. Thank you.